So this is a crack pipe.
Yeah.
It's just got residue. Yeah.
Come on outside.
34.
Can we go this way?
Your car.
Go ahead. Yeah, it's that way.
Incident date March 10. Location McLean County Retail Mall premises. Event retail theft investigation, trespass enforcement, active warrant arrest, and controlled substance discovery. This footage documents a multi-charge encounter initiated by loss prevention at a commercial retail property. The encounter raises issues under the Fourth Amendment state trespass, law warrant execution protocol, and evidence handling standards.
How's it going? Okay. Do you have things in your bag?
Huh?
Do you have things in your bag?
Yes, I do, sir.
Okay. Can you take them out for me?
Yes.
Just take them out for me. 10-4. I'm in here with her if you want to come in.
I apologize.
All right. Is there anything else in there? Mind letting me see? Can I see? Just to make sure there's nothing. Okay.
I'm sorry.
What are we doing? Okay. Did you come in here yesterday as well?
No, I didn't come here yesterday.
With a hamper? I mean, there's video of it.
Not yesterday. I did.
Brown hoodie, hamper, in here with a friend. And there's video of it. I was here last night.
I apologize, sir.
I got you. Do you have an ID or anything on you? No driver's license, state ID, nothing like that? Okay.
Am I getting arrested?
I don't know. I think what he wants to happen is you getting trespassed. So that might be what happens. I'm not for certain, okay? I'm gonna have you hang out with him, okay? I'm gonna go talk to them, see what the solution is gonna be, and we'll go from there, okay? So she had a couple of like kids' shoes. Looked like that's all that she had. Yeah. What do you guys want? You want her to trespass? Obviously, you guys are gonna get the property back.
I know they're going to want to press charges, but definitely trespass. I need y'all official on that, so she's caught on site permanently.
Okay. So, I mean, as far as what she's tried to take today, there's no offense yet. Pretty close, but not yet. So you just want to have her trespass then? Okay. All right, we'll do that. And obviously, you said she's been violent in the past and everything. She's not today. So hopefully she just won't come back here.
I'm hoping not. I mean, we've got tons of footage of her taking stuff before. You know, you seen the basket stuff last night.
Yeah. If you guys get video and everything like that, and you determine you want to press charges and everything, then you can go that route. But if tonight you just need her trespass,
yeah, for today, and then I'll build an actual case. That way.
Perfect. And we'll have her identified and everything. So cool.
Is that all you need from me?
I think so.
You're just gonna bring me paperwork on it later, or how's that work?
I can bring you the incident number. It's not the report number. It's the incident number for the call. I can give you that. I can't give you the trespass sheet itself because we have to keep that for our records. Okay. But I can come back with her name and stuff if you need that.
Yeah, just any info that I can give to my boss.
Okay, sure. It looks like you might have a warrant, okay? So I need to drop the bag. Mm-hmm.
How?
I don't know. We need to drop the bag. We have to secure you in handcuffs. We'll figure it out. Doesn't necessarily mean you're going to jail. Stop. Like I said, doesn't necessarily mean you're going to jail. Could be NTA. I have no idea.
What's in your pockets? Go ahead and throw that in there.
Okay, stop reaching in your pockets, okay?
I'm sorry. I gotta work out.
They're going to have to tell us. That's why they're asking us to secure you.
I'm just now learning this too. I'm learning it with you.
What's 99?
FDA.
99 means warrant. So you have a warrant out of Sangamon County and McLean County.
Persons
So
wanted
the Sangamon
out of
County one is for
County
larceny,
for
which is
retail theft
basically
for
retail
27 and
theft.
submitted.
McLean County, it sounds like the same
10-4,
thing.
go ahead and confirm them all.
Of course, you're from McLean County.
Well, apparently you missed it.
Are you serious? What's today's date?
Today is March 10th. Do you want to take her out?
Yeah.
Come on outside.
34.
Can we go this way?
Your car.
Go ahead. Yeah, it's that way.
You want me to go this way? Or?
Correction on that McLean County one is going to be for assault.
10-9, it's for what?
For McLean County one's going to be for assault, and they will also
Let's go
extradite.
out this way.
What they saying?
10-4.
What they saying?
She's just giving me information about what you're wanted for.
Yeah, a lot of it sounds like failure to appear for things like that.
Macon, can you start a female officer?
Way down south.
Was that traffic for making?
10-4. Can you start a female officer if you got one available?
10-4, 39, can you head up to the mall? Can you head to the mall at school to about 34?
So there is, right here in the front, weed. It looked like a white powder for the substance for a second, but it's just weed.
Okay.
I don't know what else yeah. Sorry, at first it looked like I didn't open it in there. It looked like only saw the back half.
Yeah.
Good job. Good job.
Wonder what she's gonna want to do with that then.
Huh?
So I want to see what she's gonna want to do with that. It's either throw it away or us having to tag it. I doubt she's gonna want to throw it away.
Oh, it all depends on if it's ditch weed or if she bought it at a dispensary.
Yeah. I'm just gonna run her and make sure it is who she is. Alrighty. So that's our call number, the event number, and then that's her name, and she was trespassed.
Okay, we got your name on there.
Yep.
Okay, and that's her.
Yep.
Cool.
And she had 3 separate warrants.
Oh.
Yeah. So
She's going regardless.
yeah.
Where was the stuff that she had? I gotta
I'll take that to you. Or take you to that.
I've been after her for like 2 months. They finally let me have the green light. He's like, I'll give you 30 days. If she comes back in at 1.
Yeah.
16 or Ramsey County. We're going to county or headquarters? Headquarters on that. I copy.
Walked off way. Close. So what's sitting right here? I don't know if somebody already put them away or what, but
Oh, were you looking for shoes?
Did we have those with the recovery from her?
The little kid shoes that were there? Do
Yeah.
you need them?
well, he
I
needs
will.
them. Yeah.
He does that.
Okay. I just picked them up. I didn't know what they were.
But yeah, they were right here.
Okay, I guess we're good then. Okay, cool.
Cool.
I appreciate it a lot.
Yep,
man.
no problem, man. You too.
I'm coming. I'm sorry. It's mixed up. I didn't know. I just picked them up.
Park 83, detail.
Traffic ready, sir.
10-4, I have a detail for you in a park if you're ready.
Yeah, go ahead.
It's gonna be a 9. Caller refused on the ATP. They advised Jason Isbell. Last name wearing a brown hoodie, black sweatpants, is hanging out here by the pavilion. He's 99 MSO for juvenile delinquent. He also has an alert for carrying a 32.
ISU's 1 Consensual Search 4th Amendment. U.S. Const. Amend. IV 4 Officers requested the subject voluntarily empty her bag, This constitutes a consent search, one of the established exceptions to the Fourth Amendment's warrant requirement. Under Schneckloth v. Bustamante, 412 U.S. 2181973, consent is valid when voluntarily given and not the product of coercion express or implied. Key point: the subject retained the right to refuse at any time. Consent is not irrevocable. Withdrawal ends the lawful search. No Miranda warning is required prior to a consensual encounter. 2. Identity and identification. The subject had no government-issued ID. In Stop and Identify states, a person lawfully detained must provide their name. Illinois is not a strict Stop and Identify. State refusal alone is insufficient grounds for arrest absent independent probable cause. Trespass, vs. Criminal charge 720 ILCS 521-3. Trespass to real property. Criminal charge 720 ILCS 521-3. Trespass to real property. Officers confirmed the subject had not yet crossed the threshold for a criminal theft. Charge items were in her possession, but no completed taking had occurred. This is the asportation element under theft law. 720 ILCS 516-1 requires that property be knowingly exerted with intent to permanently deprive. At the moment of detention, that element was incomplete. The legally correct response was trespass, a civil and criminal tool allowing property owners to bar individuals permanently. Video evidence from the prior night supported a pattern of conduct strengthening future prosecution under 720 ILCS 521-3A. Key lesson: when criminal elements are not fully established, trespass enforcement preserves the right to prosecute later once evidence is compiled without risking a premature charge that could be dismissed. Issue 4 Active Warrant Discovery U.S. Constamend 4 Code 99 Protocol ASSUE 4 Active Warrant Discovery U.S. Constamend. Number 4. Dispatch returned Code 99 indicating an active warrant. Officers immediately moved to secure the subject in handcuffs, which is the constitutionally required response. Under Atwater v. City of Lago Vista, 532 U.S. 3182001, a custodial arrest based on a valid warrant is constitutionally permissible, regardless of the severity of the underlying offense. McLean County warrant charges included assault 720 ILCS 512-1, failure to appear 725 ILCS 5110-4. 3 separate warrants were confirmed. Arrest was mandatory. Officers correctly noted that a notice to appear NTA remained a possible outcome pending warrant verification, demonstrating procedural accuracy in not prejudging custody. Key lesson: once a warrant return is positive, officers have no discretion to release. Failure to execute a confirmed warrant constitutes a dereliction of duty and potential obstruction.
Yeah, continue saying.
Is that what your husband or the baby's at? Is it your boyfriend or your husband? Well, when you get downtown, you'll be able to make a phone call so you can let him know what's going on. Huh?
He's gonna be a white male, 15 years old, last seen wearing brown hoodie and black sweatpants.
Coughlin.
Huh?
So this is a crack pipe.
Yeah.
It's just got residue. Yeah, I'm gonna just throw it away.
It's up to you, yeah.
I'm fine with just throwing it away. She doesn't have any like actual crack. It's
Just got a bunch of crud in here, huh?
I'm gonna throw this away, okay?
You don't have any purpose for it, right? All right. It's gonna cost you.
Appreciate it.
Oh,
Yeah, it's wonky.
here we go. Good luck to you, all right?
Thank you.
Sorry, I was trying to slip a paper, and then the neighbor was talking, and I have a bad habit of when someone's talking to me, I turn down the radio so I can hear them.
Yeah, I mean, there were shots fired, there was screaming.
That's
all you missed.
By the time she said Deputy Harris, I was like, shit.
It's all right. It happens. Happens to the best of us.
But I was actually out working, so I get points for that.
Hey, what funeral home did you have my cuss, or did you put them back?
I put them in your box.
Which funeral home is it at?
Let me look.
Did they ever come back with Sangamon counties?
I didn't hear it.
I didn't Harry Land Road on a signal 30. They were in the driveway when they saw me. They ran into the garage.
Well, I'm gonna take off.
Or it doesn't matter anyway. You still got all that other crap.
Yeah, so I'm gonna take off.
Thanks, man.
Appreciate it.
Prial, ISO 5 controlled substance discovery marijuana plus drug paraphernalia. Officers discovered marijuana on the subject's person. Under Illinois law 410 ILCS 70510 to 10 possession of cannabis under 30 grams is decriminalized for adults. However, context dispensary receipt versus street acquisition affects charging decisions. A crack pipe with residue was also found. Under 720 ILCS 600 thirds, 5 possession of drug paraphernalia with residue may constitute a criminal offense. Officers exercise discretion to dispose without tagging a decision that carries legal risk if challenged later. Key lesson: residue inside paraphernalia can constitute possession of a controlled substance under Illinois v. Leeson and similar state precedent. Disposal without documentation eliminates the evidentiary record and may violate chain of custody protocol. ISSU 6 Juvenile Warrant Separate Detail, Code 99, Juvenile Delinquency 15, Year, Old Male ISU. A concurrent radio dispatch reported a 15-year-old male with an active Code 99 warrant for juvenile delinquency. Under Illinois Juvenile Court Act 705 ILCS 4055-105, a juvenile subject to an outstanding warrant is subject to custody and transfer to juvenile intake, not adult booking. Officers are required under 705 ILCS 405-5-605 to notify a parent or guardian at the earliest practicable time, a procedural obligation distinct from adult arrest protocol. This is legal lessons learned. Legal lessons learned. 1. Consent searches. Always document that consent was voluntary. Any ambiguity invalidates the search under Schneckloth. Officers should verbally confirm consent before proceeding. 2. Charging threshold. Initiating a charge before all elements are established risks dismissal. Trespass is a legally sound alternative when the evidentiary record is incomplete. 3. Warrant execution. A confirmed warrant eliminates officer discretion. Detention and handcuffing are lawful and required. Illinois v. Wardlow 528 U.S. 1192000 confirms flight or evasion in a warrant context provides independent probable cause. 4. Evidence documentation. Paraphernalia with residue must be tagged and logged, not informally discarded. Failure to document compromises the arrest record and may expose officers to allegations of evidence tampering under 720 ILCS 531-4. 5. Juvenile protocol. Juvenile detainees trigger a separate legal framework. Adult procedures do not apply. Failure to notify guardians within the statutory timeframe constitutes a due process violation under U.S. Const. Amend 14-4. Lou. Video evidence as probable cause. Prior conduct captured on security footage constitutes admissible evidence under FRE 401 and supports probable cause for future charging, provided the footage is preserved under proper chain of custody.